afternoon, everyone. Thank you for joining us today. To briefly introduce myself, my name is Kelly E., Counsel and Chief Representative of HKIAC's Seoul office. It is a pleasure to have you all join today to kick off the third HKIAC Korea office webinar series. Today's webinar is on the two important E's in running and managing an international arbitration matter: efficiency and effectiveness. Some critics have continuously raised concerns on whether international arbitration is a cost and time-efficient means of dispute resolution. Despite these concerns, international arbitration is going strong, and even with HKIAC, we have continuously seen increase in our caseload. Nonetheless, there are things you can consider and measures you can take to make even more efficient than effective arbitration. We have three distinguished guests, arbitration specialists as guests here today to share these measures with you all. Dr. Eun-young Park from Kim and Chang, Seoul office, Brenda Horgan from Herbert Smith Freehills, Australia, and last but not least, Anthony Houghton, SC from DeVos Chambers. While reviewing the presentation, please send through any questions you may have in our Q&A box at the bottom of our screen, and we will cover that during our Q&A session at the end of the webinar. So to get started, let's see. Before we get to the substantive part of our webinar, we are pleased to reveal our new logo at HKIAC. It represents our commitment to a meaningful innovation. Much has changed since HKIAC's logo was last updated a decade ago, and HKIAC has much to be proud of today as one of the world's leading dispute resolution centers. We have also recently published our 2020 statistics, and for more information on our services and statistics, please visit our website at hkiac.org. Now, getting to the more substantive part of the webinar. We are proud to first introduce Dr. Eun-young Park, who will be covering things to consider before initiating an arbitration and strategic considerations that are involved early on with clients, even before filing a notice of arbitration. Dr. Park is a partner at Kim and Chang, who serves as a co-chair of the International Arbitration and Cross-Border Litigation Practice. He has played an active role in the development of international arbitration practice. He has practiced under the rules of the renowned arbitral institutions and also sits as an arbitrator in international arbitration cases. He is currently serving as Vice President of LCIA Court and is a member of HKIAC Court of Arbitration. And he is also on the board of Korean Council of International Arbitration and executive member of SIDRC. He also practices in anti-corruption and regulatory compliance and international trade and customs. So without further ado, I introduce Dr. Park. Thank you, Dr. Park.
Thank you, Kelly. Thank you very much. I'll start with the nature of arbitration. What is arbitration? Arbitration is contract disputes. To some, contract would be obvious to them, especially when they are the transactional lawyers or in-house counsels. When they have a arbitration, a contract dispute, they think that the contract is clear to them. And they sometimes say that the contract would mean this and that based upon their negotiation history. Nevertheless, once arbitration is filed, the whole dynamic is changing because it really depends upon what jurisdiction that you are bringing your case. If, for example, a civil law country is a seat or it is a governing law, then the whole negotiation history will come in. But if you choose a common law as a governing law, then the contract would be only limited within the four corners of the contract, and the negotiation history may not be brought in. So it really depends upon the dynamics of the arbitration. Second misunderstanding of arbitration is that it's similar to litigation. So you would think about the discoveries or technical motions and whatsoever, but arbitration is different from litigation in many parts. So you need to understand these contractual aspect at the same time dispute aspect to fully understand arbitration. Next page. So I'll talk about 4 elements as an initial matter. I'll talk about the client first. As an early foundation, you need to talk to client to advise as to what arbitration is about, and then the dynamics of the arbitration. So you have to have a continuous communication and consultation with your client. This is for providing clients with information about arbitration procedures, and also discuss with them as to the technical decision-making process, such as appointment of the arbitrator or the making of objections and document productions. The next item is on the arbitrator. The next slide, please. So there are a big issue of appointing arbitrator. Different from litigation, arbitrator is appointed by the parties. Party has autonomy to constitute the arbitral tribunal. Normal method is to appoint their arbitrator respectively, and then the third arbitrator will be determined by the agreement of the arbitrators or the institutions. But it is very important to have a proper person as an arbitrator, and it will regulate and govern the entire process of the arbitration as well as the outcome. I wouldn't go into detail about the arbitrator selection because it will be covered by the next speaker. And then the third one is witness in the next page. Even though you have an early phase, it would be good for you to talk to witnesses to investigate properly as to the factual backgrounds, which will be used in building case memorials. And it is good to connect initial facts of the case with key documents in an early stage, and you talk to witnesses to see if what their memories are, whether the witnesses would be supportive. Based upon all these, you can build up an overarching theme and favorable narrative of the case. The next item, next page, is expert. In arbitration, expert may be needed for some industrial background or legal principles. Normal practice is to present your own expert, expecting that the other side would present their expert as well. So it would be good for you to know what the outcome of the expertise that the expert would present. The next one is on the assets and enforcement. One initial issues to consider is identifying assets. It is prerequisite to any effective enforcement strategies. You need to always undertake proper due diligence research for counterparties. To identify what assets their counterparty has. You might think about retaining an asset tracing firm before commencing the case, because it will affect your power to enforce your word. So at some point, you may consider provisional remedies like attachment or injunction from the outset. And also, the asset and their location can be a source of the jurisdiction that the parties can choose. The next page is about the financial status. Financial status should be determined for 2 reasons. Number one, you need to probably preserve a status quo. In certain circumstances, you might seek a freezing injunctions if their financial status is not good. Also, in case there is a problem of financial status of the counterparty, you might apply for a security for costs. The next is on the interim measures. Interim measures are a certain measures that you could consider to avoid a certain divestiture of the assets or scattering of the evidences and so forth. Major arbitration institutions provide a ground that arbitral tribunal has authority for interim measures. For example, Hong Kong IAC rules have such provisions. Examples of interim measures are including an order to provide letters of credit, or enjoining parties from transferring assets, or taking certain actions to terminate agreements, or any action disrupting status quo prior to final decisions. It also is related to preserve certain evidences. Next. Seat of the arbitration generally provide grounds for this arbitral tribunal's wide power. For example, Korean Arbitration Act, Article 18 provides such a power. A tribunal has a power to grant interim measures as deemed necessary. As you see, it is to maintain or restore the status quo, or take action that prevent harm or prejudice to the tribunal arbitral proceeding, provide a means of preserving assets, and also preserving the evidence is another example. Next. In addition to the tribunal's power for the interim measures, court can also a source for you to seek an assistance. Korean law, for example, Arbitration Act of Korea, Article 10 provides that a party to arbitration agreement may request before the commencement of or during arbitral proceedings from a court an interim measure of protection, and for a court to grant such measure. Korean court actually provides various cases. One of the cases is to confirm that the court has a power to grant a conservatory measures, but they didn't expand the scope of the measures. It's only limited to the conservatory measures. And also court granted a preliminary attachment to preserve arbitration costs. The next one is about the common law jurisdictions. The United Kingdom, for example, has Arbitration Act, which provides that High Court has power to issue a Moreva injunction in relation to international commercial arbitration. It is basically a freezing injunctions. Singapore, another common law country, has a similar provisions in their Arbitration Act. Claimants need to show there's at least a good arguable case that they would succeed at trial. Typically, it includes undertaking to compensate the defendant for any loss caused by the order. So it is really depend upon what jurisdiction that you bring these interim measures from the court. So that is wide range of options, and you have to think about what actions you could take, whether you go to the arbitral tribunal or to go to court. The next one is on the emergency arbitration. Hong Kong Arbitration Center, International Arbitration Center, provides in their rule that you could apply for an interim relief, urgent interim relief, prior to the constitution of the tribunal. As mentioned earlier in the interim measure section, you could apply, seek interim measures from the tribunal. But what if you have an urgency, but the tribunal was yet to be confirmed, then you would consider seeking an urgent relief to emergency arbitrator. An emergency arbitrator is specially appointed for this purpose. KCAB, for example, also provides this emergency interim relief. Next. There is an issue of standard for granting emergency arbitration relief. Most institutional rules are silent on the applicable standards for granting emergency arbitration relief, and there is no universally applicable test. The rules typically grant a wide discretion to emergency arbitrators. It only circumscribed by a region of appropriateness, urgency, or necessity. Based on the emergency arbitration decisions, one can find well-established three key factors that emergency arbitrators typically consider. Those are urgency or irreparable harm, or proportionality or balance of convenience, and likelihood of success on the merits. Next. Now, the types of emergency relief is such that you maintain the status quo or recovery of a status quo, secure assets, preserve documents and evidences. Examples of emergency arbitration are as wide as such that provisional measures to limit or prevent performance bond calls, or provisional measures to return the received amount if it relates to performance of the bond. Or one could file an order of foreclosure sale of goods in dispute to prevent it from decomposition. If certain products, for example, is a fruit, if it is about to be decomposed, then you could seek a foreclosure sale of the goods. Or also another example is to seek an order to submit an inventory of assets, or order to preserve or provide records of documents. Depending upon the jurisdiction or the emergency arbitrator, it could be as broad as seeking anti-suit injunction. We see a lot of different type of emergency arbitration relief. I think it really depends upon how you frame your case and explain the urgency methods to the arbitrator. Next. I mentioned about the nature of arbitration such that it is a contractual disputes. Now, if you understand the nature of the arbitration, it is fundamentally based upon party autonomy. You have some right to appoint arbitrator, and then you can make some input in framing the procedural rules. So it has a nature of dispute resolution, but it is different from litigation. So I would say that it is almost like a taming the beast, but such taming the beast would really rest upon how you design your arbitration. Thank you.
Thank you, Dr. Park, for your informative presentation. Dr. Park has helpfully explained various issues to consider at the initial stages of dispute. Before we move on, just one thing I would like to add is that the emergency arbitrator proceedings, in our HKIAC rules, in our 2018 amendment, we had explicitly included the emergency arbitrator proceedings in our rules under the Schedule 4. And effective November 1st, 2018, we have specified in more detail of the emergency arbitrator proceedings. We have put a cap on fees, slimmed down the time limitations, and we appoint within 24 hours, and the decision is usually made within 14 days. So most often much faster than that, in some cases within 2-3 days. So just FYI on the new amended rules. Thank you, Dr. Park again. And next we have Brenda, who will be further discussing the arbitrator selection proceedings. Brenda is head of international arbitration in Australia for Herbert Smith Freehills and has experience of arbitration cases across the world. Brenda specializes in international arbitration with particular focus on disputes involving emerging markets. She has worked from the US, Paris, Moscow, Shanghai, and now in Sydney. In fact, I had the pleasure of working with her when she was stationed in Herbert Smith Freehills Shanghai office many years ago. She has experience in international commercial and investment treaty arbitration matters at both arbitration and enforcement stages as counsel and also as an arbitrator. Thank you, Brenda, for being here today.
Thanks, Kelly. So, although this is a session around efficiency in the conduct of an arbitration, one of the most important elements of your arbitration and how it's conducted is the arbitrator selection process. And the arbitrator selection process doesn't actually start once you're in a dispute. It starts with the rules that you write into your contract at the contract negotiation stage, because there are many elements of that process that you can either streamline or introduce complexity that will result in confusion and delay. So I thought we'd start just briefly with actually drafting the arbitrator appointment process in your contractual provisions. First question, of course, how many? Almost always that answer is either 1 or 3. If you are in a large transaction that is likely to result in a large dispute, it's usually safest to go with 3. There are instances where you have things happen to arbitrators and you want to continue the arbitration and not have to start entirely over. And that is sometimes possible depending on where in the process you have difficulty. I have had arbitrators who have died, who have been medically incapacitated. So having 3 people is just a safer option. Plus you have the ability of those 3 arbitrators to compare notes, to compare thoughts, and you're more likely to come up with an outcome that is not out in left field. Obviously, if you have a small dispute, a small transaction, 3 arbitrators is probably cost prohibitive, in which case choosing 1 is absolutely fine. Do not choose, as I have seen in a couple of arbitration clauses that came across my desk from other firms, don't choose an even number. If you appoint 4 arbitrators, you're going to have hideous difficulties because you need that odd number in case there's division within the tribunal. The next thing that companies will often ask to include is a lot of detail around the procedure for appointing the arbitrators. But the reality is that all of the major institutional rules, including the HKIAC rules, have established procedures written into the rules, and you don't need to replicate them in the clause. And actually, if you replicate them in the clause, you're likely to introduce inconsistencies, uncertainties, and potential problems. It's better to use the standard language provided by the institution and then add in the special bits that you need, the language, the seat, the number of arbitrators. But other than that, specifying this one is appointed by the parties, that one's appointed by the parties, then the two of them agree, when all of that's already included in the rules, is unnecessary and unwise. That's particularly true in a situation where you have multiple claimants or multiple respondents, or the potential for multiple claimants and multiple respondents. All of the major institutional rules now have special procedures for clumping parties into respondent groups and claimant groups. And if you try and change that by saying, Party A will appoint one arbitrator, Party B will appoint another arbitrator, and Party C will appoint the third arbitrator, you automatically introduce three problems. One, you might not necessarily have all three parties participating in the arbitration. Two, you don't have a designated chair because each of the parties has appointed one of the three, and there's no one in control. And three, you've adjusted the rule system in a way that's incompatible with these concepts of claimant and respondent groupings. So it's better just to let the rules do the talking and keep your arbitration clause short and simple. Now, there is a common exception here in terms of appointing the chair. And that's because certain rules, and the ICC and HKIAC rules in particular do this, default to the institution appointing the chair unless the parties have provided otherwise in the clause or have agreed otherwise in the course of the lead up to the proceedings. Often the parties want more control over that process. They don't necessarily have a clear understanding of how the institution would make that appointment. And so it's often advisable to write in the ability of the two-party appointed arbitrators to choose the chair in those circumstances. The HKIAC rules do that automatically. You don't need the extra language, but for the ICC rules and HKIAC rules, if you want the two-party appointed arbitrators to be appointing the chair, you should say so in the clause. Then you get into some interesting, what seem like minor grammatical or punctuation difficulties that, if you're not careful, can really derail your arbitration early on. One of them is doing an autocorrect throughout the contract to change lowercase party to uppercase party. If you have uppercase party in your arbitration clause and you have three or more parties, de facto, you're giving each named party in the contract an ability to appoint an arbitrator, which is not what you wanted to do. So make sure that you go through and that your arbitration clause references to parties are to lowercase parties. Another thing that I've seen come up, and it's a few of you have heard this story, we affectionately call it the case of the $45 million comma. Bilingual contract, both languages equally authentic, which is always problematic to begin with. But in one of the languages of the contract, the placement of the comma within 60 days, comma, meant that you had to bring your arbitration within 60 days of a dispute arising, or you lost jurisdiction. In the other language, the placement of the comma was such that you had to wait 60 days before you could go to arbitration. So completely incompatible clauses, both languages equally effective. So make sure that your arbitration agreement, if you do have two languages, have one controlling. If you have to have them both controlling, make sure that they're identical. Another thing that corporates will often ask for is inclusion within the arbitration clause of qualification requirements. That can be okay if you're extremely narrow and explicit as to what your qualifications are. But say you put in something like experienced in engineering, Well, how do you tell if you're experienced in engineering? A sharp respondent is going to say, oh, but they're not experienced enough. That gives me a ground to challenge that individual. And that will add delay and cost to your arbitration proceedings. The worst situation that I have seen was a qualification requirement that said, and this was in a CTAC arbitration, where all of the arbitrators had to be chosen from the CTAC panel. There wasn't a written exception into the clause for off-panel appointments. And the clause provided that all of the arbitrators had to be fluent in English and Mandarin, and that the chair could not be, and this is pre-Brexit, so back when the UK was still part of the EU, the chair could not be a national of the EU or China and had to be Hong Kong qualified. So that immediately took out all of the UK qualified people living in Hong Kong and working in Hong Kong. It immediately, because the Chinese Nationality Act includes Hong Kong, it took out all the Hong Kong practitioners. And so you were left, and you had to be someone who was named on the CTAC panel, and you had to be Hong Kong qualified. So in the end, we were left with 5 people to choose from. 1 had been appointed by the other side, 3 were conflicted, and there was 1 person left. So it looks innocuous, but the qualification requirements, especially if there are multiple requirements that are layered, can be very dangerous and can severely limit the available pool of arbitrators. One exception here for a qualification requirement that is recommended is if you are including a China-related clause and you're seated on the mainland, it can be helpful to specify that the chair will not be the national of either party, and that you can make off-panel appointments. So all of that to say that a lot of the issues in your arbitration actually should be addressed before you ever sign the contract, because the appointment process and your arbitrator selection provisions in the contract can have a significant influence on your later flexibility in appointing the arbitrator. Next slide, please. So when you get to the point of choosing an arbitrator, what are you looking at? There are lots of factors, and most of these factors will apply both to the selection by you of your party-appointed arbitrator and to the selection of ultimately the chair, assuming the parties have the ability to influence that selection. So clearly, commercial and cultural know-how. In much of Asia, you would want someone who has some experience with Asian realities, Asian commercial approaches to contracts. If you were arbitrating a dispute between a Russian entity and an Uzbek entity, you'd want somebody who understood that environment and the circumstances that arise in that context. Similarly, for any particular seat and jurisdiction, you're going to want to have that cultural know-how, because there are situations in which companies simply take different approaches to, for example, documents and evidence. So if you are an American trained lawyer who's only ever practiced in the US, you will expect corporates to have rigorous document retention policies, to keep immaculate records, to cover things off with privilege that you don't want to have disclosed, all of these elements that go into a common law approach to evidence. If you're in a civil law jurisdiction, where in a litigation context, there's no disclosure of documents or virtually no disclosure of documents, you don't have those same kinds of restrictions unless you're operating, continuously operating across both civil and common law situations. So you would want to make sure that whoever you have as your arbitrator understands that your company in a civil law jurisdiction has a different approach to documents and may not keep everything or may keep too much. And that's just a factor of that different background. Other things to take into account: language skills. In the example that I gave, the arbitration agreement required the arbitrators to be fluent in English and Mandarin. So you need the Mandarin. You'll often want to have some language ability if there's going to be extensive documentary submissions in that language. I'm going to skip procedural preferences for a moment, go on to legal expertise and preferences. Some cases are heavily fact specific. Other cases are black letter law specific. You might want a black letter lawyer in a particular case, or you might want someone who focuses more on the equities of the case and gives weight to what the parties thought they were intending as opposed to the black letter language of the contract itself. So you have to evaluate what those considerations are and look at the arbitrators who fit that description. But be careful, because you might think that your case is a narrow case about equity. The other side might raise a counterclaim that's black letter law. So you don't want to go too far in either direction. You want to stay somewhere close to the middle so that whoever you appoint is capable of dealing with both aspects. Availability is key. Many years ago, there was an arbitrator in Paris who was very well known, very good, very well liked, and completely overworked. And if you went to any cocktail party, you could stand around in a group of 5 or 6 people and you would say, I'm waiting for an award from arbitrator X. And everybody else in your group would be also waiting for separate awards from arbitrator X. That has been significantly reduced by the focus of all of the institutions on ensuring that arbitrators are available, but it is still something to take into account. The most popular arbitrator is not necessarily the best arbitrator for your case. Diversity is another key element, and this is not just because we're trying to promote ethnic diversity, gender diversity, age diversity on tribunals, although we are. It's also good for your case to have diverse viewpoints, diverse understandings of factors and elements, and difference in thought. It enhances the communication and the debate within the arbitral tribunal. Another factor there which relates is the other chosen arbitrators. You don't want to appoint someone who can't stand to be in the same room as the other party's appointed arbitrator. If they hate each other, they won't debate and you'll have a bad outcome. At the same time, if 2 of the 3 are way too friendly and the third gets left out in the cold, you won't have a good outcome. So you have to identify who those individuals are and how that might affect your case. Coming back to procedural preferences, this is something that's really more important for the selection of the chair. And it goes to the question of some arbitrators have a reputation for being relatively hands-off on your case. Some arbitrators have a reputation for being very proactive and encouraging procedural efficiencies and pushing the envelope forward in terms of early case management conferences, early expert meetings, all of these things that can move your case along more quickly. If you're a claimant, you probably want that second type of arbitrator. If you're a respondent, you might not. So you have to think about, but you don't want somebody who's so disconnected with the other 2 arbitrators that they lose credibility within the tribunal. So you have to balance what the approach is and what makes the most sense. All of this entails knowing the arbitration community pretty well and keeping kind of internal databases of who approaches things in what way. And then there's the overarching element that no firm can appoint an arbitrator more than I think it's 2 times within a 3-year period. You have to be careful about the conflict issues, and you have to make sure that the arbitrator is sufficiently engaged that they will provide all of the steps within the time periods that you need them. Next slide, please. So how does this process actually work? So for the party appointed arbitrator, the lawyer will present a short list of arbitrators to the client. And many firms are now saying that those short lists have to be diverse, and the client has to at least be given the opportunity to appoint someone other than the usual suspects. You would want the people on that short list to confirm their availability, their independence, and their freedom from conflict. That's going to be done again by the institution, but you don't want to put forward someone in your pleading that you then have to immediately replace. So you want to check that all yourself. And then you designate the name of your arbitrator in your first submission, at least according to the HKIAC rules. And for the party appointed arbitrator, if a party fails to appoint that arbitrator, HKIAC will then appoint. Under the HKIAC rules, those 2 arbitrators then confer and agree on the designation of the chair. And if they can't agree, HKIAC makes that appointment. The key, though, to remember is all of these designations have to be confirmed by the HKIAC. And that's a mechanism by which the HKIAC can step in and say, wait a minute, this person is conflicted, or wait a minute, this person already has 15 arbitrations on foot. We don't think they're available enough, and we don't confirm their appointment. There are other grounds for refusing confirmation, but the 2 big ones are conflicts and availability. And I will stop there and pass on to the next speaker.
Thank you, Brenda, for your presentation. Being able to choose the judges who will be deciding the fate of our dispute is really a key distinguishing feature of arbitration, and I would say one of the most important processes. One thing I would also note is that HKIAC has an appointing committee, and the committee is formed of various arbitration specialists from various jurisdictions, including Hong Kong and UK and all the other jurisdictions, including common and civil law. This appointing committee is the one that will be considering these designations and making the confirmations. They work pro bono, and anyone conflicted from making this decision will waive their right to be involved in that process. So it's a very transparent and very neutral appointing confirmation process. Next, we have Anthony, who will be discussing the practical tips in oral advocacy skills and to achieve effective advocacy in a hearing, and also what you should ultimately aim to achieve from your submission in the hearing. Anthony started his professional career as a surveyor in the UK, and he also has experience working in Asia. He then became a barrister in the late 80s and has practiced law in both in-court proceedings as well as arbitrations. His practice is in general commercial disputes, particular focus on construction and engineering matters that derives from his unique dual professional qualification. He's a very well-recognized counsel and an arbitrator. I believe he will be able to provide a very insightful practical tips, putting on both his counsel and arbitrator hat. Anthony, I pass on to you. Thank you.
Thank you very much, Kelly, and good afternoon, everybody. It's a great pleasure to be able to talk to you today. I'm actually going to try and widen the brief I've been given slightly, in that I'm not going to focus just on advocacy in oral hearings, because in my view, in my experience, there's actually a lot more to advocacy than simply the metaphorical standing up in the hearing and addressing the tribunal. So I'll try to broaden it a bit. But with the first slide, what I would like to do is to introduce to you the fact, or the concept for some of you perhaps, that the process in arbitration is essentially much broader than you might think with traditional litigation situations. Dr. Park has already drawn to your attention or reminded you of the differences that may exist between civil and common law approaches. And I think it's probably fair to say that for international arbitration, it is something of an amalgam between those two processes. It is not, well, it is flexible. That is the key point to be made. It is not rigidly civil law in approach. It is not rigidly common law in approach. It tends to try to merge the two processes, and that will more often be the case when the parties themselves come from different backgrounds. Maybe one's a civil law jurisdiction-based company, the other a common law-based company. So the tribunal will, or very well may, in those circumstances, seek to find an amalgam approach. And the way you approach your advocacy then, the attempt you make to persuade that tribunal will perhaps have to adjust depending upon the nature of the circumstance that you're in, the particular type of arbitration that is crafted for your dispute. The other point I want to make based upon this slide really is that it's not always the case that there will be an oral hearing at all. It's not necessary in international arbitration. It very much depends on the circumstances of the dispute, the wishes of the parties, a variety of factors. But it may well be that in a simpler case, it'll be decided, the dispute will be decided simply on the basis of documents. And of course, in that sort of situation, the approach to advocacy clearly has to be different. It's crafted in the documents. In a legal submission, perhaps, there is no evidential hearing at which the traditional, what I think of as traditional oral submissions can be made. So against that sort of background, Kelly, if we can move on to the next slide. And I think this is perhaps teaching many of you to suck eggs in an old-fashioned phrase. It's really teaching the basics. What is the advocate trying to achieve? This is the question for everybody to keep in mind, I think, when they come to approach advocacy. And for me, I think it falls into three little groups. The first of these is education of the tribunal. The middle group on that slide is explanation. And then the third component is the one that people perhaps focus in on a lot, and that is persuasion. Now, why education? Well, this is where I think a lot of the hard work of advocacy actually is done. And really, it's a very simple concept. The tribunal comes to the case fresh. They don't have the background that the parties do. They haven't been writing horrible letters to each other for 6 months or a year or 2 years. The tribunal comes in completely ignorant of the background, and they need to be brought up to speed as to what it's about. Now that has, I think, two elements to it. One is filling in all the necessary detail, but secondly, it's that word necessary. It's trying to focus in the tribunal on what is in particular relevant to the dispute and relevant to the issues between the parties. The second component is explanation, and this may involve going into technical areas. Brenda has already spoken to you about the importance of arbitrator selection, and I would underline everything she has said about that. It's a very important fundamental element or aspect of arbitration, the choice of the tribunal and getting the right person or people to decide the dispute that you have. And part of the advocacy process in my book is trying to explain to them the relevant facts, the relevant background, and getting up to speed as to why your client has the particular case that they do, why they say there's been a breach, or indeed why they say there hasn't been a breach, why they say things happened or why they say they didn't happen. And this is an ongoing process, clearly, right from the very early stages through to the end. The third element, and the part that people sometimes get particularly hung up on, that's the persuasion. And for me, that is the 10% element. The big work, the hard work, is in education and explanation. Persuasion is the icing on the cake. It's the little trimming that brings the case home at the end of the day and explains really why you're right and the other side are wrong. So Kelly, on the next slide, please. I think a good way to look at advocacy in trying to develop a successful approach in a case is to think, what does the tribunal itself want? We've already mentioned, I've mentioned the fact that they start from a position of relative ignorance. They don't know the facts, they don't know the background. So what they want, I suggest, and I can say this from my personal experience sitting as an arbitrator, some guidance through the process, a roadmap, if you like, an indication of how this dispute developed, how it's going to go, and where you want to go, where the tribunal may want to go in terms of deciding the issues. At the early stages, they want a guide, they want a roadmap as to how to identify the issues. And that goes then into the second box, where there needs to be some degree of focus in what is submitted to the tribunal, so that they can assist the parties in narrowing it down, in trying to identify clear, as far as they can be made, clear issues, calling for a decision by them at the end of the day, on the assumption that the matter doesn't ultimately settle. And that will follow as a natural process as the arbitration develops, as the process goes on, so as to result in offering answers that you think are right answers to the specific questions that the tribunal is being asked to decide. Now, an advocate that can take the tribunal through that process, give them the roadmap, identify the issues for them, give them answers, is going a long way towards satisfying the requirements of a tribunal in being helped to answer the issues that face them. Obviously, the advocate on the other side is going to be trying to do the same thing and coming to different conclusions. But if the tribunal can't really understand your position, they're not going to be likely to agree with you on what the answers should be, or certainly less likely to agree on what the answers should be. So clarity in approach, making it simple for the tribunal, leading them through the process, I think are key elements of advocacy. And these run right through the process, not just in the oral hearing, not just at the oral advocacy stage. Again, next slide, please, Kelly. So this is the point that I've really just made. We have a little flow diagram. When, where, and how does an advocate advocate his client's case? Well, in my submission, in my experience, the good advocates will be advocating right from the very outset. The very start of the process, the notice of arbitration, you have an opportunity to set out what the issues are, what you believe the issues are, what you understand to be the relevant facts, what you understand to be the appropriate relief to be given. That will be amplified through the exchange, very often the exchange of pleading statements or memorials. It will be an aspect of documentary requests. If you have a process where you can seek documents from the other side, then again, it will be an opportunity to leverage the education that you've given to the tribunal in terms of obtaining the documents that you want. Absolutely, you will want to use advocacy skills in tailoring the evidence. And by this, I mean not framing up evidence that is misleading or dishonest or anything of that sort. What I mean is selecting what is relevant for the tribunal to know, not burying them in so much detail that they can't pick out what is important and what is not giving them so little information that they're unable to answer the questions they have to answer, but in giving them a sensible, clear, concise summary of what it is they need to know to be able to answer the questions. And then all of that process leads you up to the submissions, and whether those are done orally or whether they're done in writing or some combination, that's the process where the persuasion can really come in. But it can't be left on its own. It requires that process all the way through to produce a beneficial result, and certainly a persuasive argument at the end of the arbitration process. So that really is the key there. It's a consistent thing that runs all the way through. Next slide, please, Kelly. So planning the hearing, well, is that advocacy? Well, in my view, yes, it is, and it's a very important part of advocacy, because there are many constraints on a hearing when one is convened. Well, there's a number of little boxes circling around the hearing here, but you can actually start with almost any of those because there isn't a sequence for it. Well, let's take it from the top. Let's look at time allocation. When you come to present your case, whether you're claimant or respondent in an arbitration, you will have normally a variety of materials that you've got to put before the tribunal, and the other side's materials that you want to challenge, to cross-examine, whatever it may be. It's an important skill, in my view, to look ahead to the hearing at a reasonably early stage and start to allocate your time. How much time do you have to spend on cross-examination? How much time do you have to spend on the documentary evidence? How relatively important are those things? So those are decisions that want to be made early so that the hearing can be conducted in a way that gives the best presentation to your case. Move round one box, the chess clock. That is a process that is quite commonly used in international arbitrations, which manages the time available to each party to ensure that the hearing will finish within the specified number of days or hours that has been allowed for the hearing. If there is a chess clock, if there is a constraint on time, that works in tandem with the time allocation box, so that you are challenged to make the best use of your time and you allocate it efficiently, because once you start, there is relatively little room for maneuver. You are boxed in to the use of your time. You need to give careful consideration to the sequence of your evidence. Normally, you will give factual evidence before expert evidence, but you will wish to probably juggle the balance between those. Do you want to give primacy to the expert evidence? Is it a highly technical case where the views of the experts are going to be the real key deciding factors? In that case, you're going to allocate time to those. You're going to allocate time that you spend on cross-examining or making submissions to those sorts of things. On the other hand, if it's really all going to turn on the facts, and you think you have a strong case on the facts, that's where you're going to put your time and effort. So the sequence of material and the fact and expert balance both have to be considered in advance. The sequence is also important in terms of your witnesses. If you have several factual witnesses, you will probably want to give some consideration to the order that you put those in. Do you start with all the strongest witnesses, the guys, the people who were most heavily involved, and just bring the bit players at the end? Do you have a strong witness to start with, some of the bit players, a strong witness at the end to sort of bookend the submissions, the case? It's a choice that will vary depending on who those witnesses are, the skills, the abilities, how well you think they'll perform, how important you think their evidence is. And again, that's a decision to be made, which will essentially have an important element in terms of persuasion of the tribunal. You want the tribunal to walk away at the end of the factual evidence having a good impression of your factual witnesses. So you may well want to save some of your best to the last. On the other hand, if you put all the good witnesses at the end, it may be too late. Tribunal may already be persuaded that you have a weak case. So you have to judge and balance the strengths and weaknesses of your witnesses. Documents, well, very often these speak for themselves, but how much time are you going to spend at an oral hearing going through documents? It may be a waste of time if the tribunal has read them. On the other hand, taking the tribunal through a sequence of documents, contemporaneous exchanges between the parties, can be a very powerful way of showing why you are right and the other side are wrong in terms of what you say factually happened and what the right consequences for the tribunal to reach are. Again, it's a judgment call as to how you balance up these various factors. Finally, in the sequence that I've gone round here, of course, we come to submissions. Are you going to make those orally at a hearing? Are they going to be done in writing? If they are being done orally, are they going to be complete or partial? Are they being done right at the end of the oral evidence, or are they be done separately? These are all various matters to take into account. Now, all of this in the modern day and age, and in particular in the circumstance that I'm talking to you at the moment, has to be also taken into account in the fact that some or all of this may be done on a Zoom platform or something like this. It'll be done virtually, where the advocate, the tribunal, the witnesses may all be in different places. And again, that alters the dynamic, in particular relating to the way that the witnesses are dealt with. It may alter the way in which you think you can cross-examine, the benefits you can get from cross-examination and the strengths of that process. So again, these are all factors that must be taken into account at a planning stage, and this is before the advocate gets to open his mouth at the hearing at all. Next slide, please, Kenny. Now, one aspect of arbitration that doesn't really arise in most places in terms of a comparison with court proceedings is the concept of witness conferencing. This is sometimes called hot tubbing, and it's a process that's used with expert witnesses in particular, but sometimes with factual witnesses in some international arbitrations. Now, the process, for those who are not familiar with it, is one whereby the tribunal essentially takes the lead in asking questions of the experts. The experts will give evidence. Let's say there are two engineering experts or two quantum experts, one from each party. They will take the lead in giving the evidence. They will sit together giving their evidence, and the tribunal will take the lead in asking questions of them. Now, there are two, I think, countervailing considerations here. One, the up arrow on this particular slide, is the relevance of the questioning, and the down arrow, the countervailing consideration, is the degree of control. Now, on the left side of that scale, relevance clearly increases as far as the tribunal is concerned, at least, if they take the lead in asking the questions. Obviously, they will ask questions that they think are important, areas where they want assistance, and that will inevitably follow that if they take the lead in asking the questions will be relevant as far as they are concerned. For advocates and for the parties, there is a loss of control in that process because the advocates themselves, and there are different approaches to hot tubbing and witness conferencing, but the advocates themselves play either a subsidiary role or indeed a very limited role in questioning of those witnesses. So they have given up that control to the tribunal. Whether you, as an advocate, want to try to ask the tribunal to follow this process, or whether you prefer to maintain control, is very much dependent upon a whole variety of things, one of which is your own confidence in ability in controlling the witnesses and asking the right questions, one of which is the ability of your witnesses to be left independently to answer questions from the tribunal. But the biggest factor perhaps is the amount of trust you can place in the tribunal to have done their homework, to fully understand the issues and to ask really the key questions. Now that, again, it varies from case to case. Some tribunals are better than others. Some tribunals are very good on technical areas because they have a lot of experience or they have members who have technical qualifications. Others, maybe not so much. So it's a decision that depends upon a variety of factors. But again, in terms of the advocacy approach, it is an important one because as you give up control, you give up the ability to add persuasion to what it is you're trying to do with the tribunal. Next, please, Kenny. So written submissions, I mean, these are the well-known areas, perhaps. I think essentially we run into three areas. There is evidence, and we do two things in advocacy with evidence, in my view, particularly at the end of the process. What you do is you summarize the evidence as you've seen it. Clearly, you emphasize the points which are good for your client's case. You de-emphasize the points that are bad, but you can't ignore the bad. What you try to do, and this is the right side of the box there, you try to bring the focus where it suits your client. Ignoring the bad side at the end of the day isn't really going to help. You have to try and provide some assistance to the tribunal so that they see the merits of your side of the case and downplay the merits that the other side may have. With the law, we have two sides again. There's the explanation of the law, and you might hope a legally qualified tribunal would be reasonably well up to speed on that, but everybody needs either refreshing or bringing up to date or being informed of new areas perhaps. And then there's argument. There may be cases that go either way. This is particularly important in a common law context where precedent authority is of particular weight, and there'll be legal argument. That's the bit that lawyers love. That's the advocacy bit that everybody is very comfortable with. I don't need to say too much about that, probably. But then for persuasion, to me, the important thing is to have answers to everything. Really, you want to have a coherent summary of the case that not only sets out why your arguments are good, why your view of the law is right, but also gives the tribunal some comfort that they can disagree with the other side reasonably and with everything dealt with. Nothing just simply brushed under the carpet or ignored. Try and deal with it. And that way the tribunal has some comfort that if they're following you, they're going down the line that you want them to go down, that they are not missing or leaving out anything that they should deal with. Next slide, please, Kelly. Finally, I think three areas or techniques that you want to avoid, and I hope these are obvious to all of you, and I'm wasting your time by saying this, but I know from experience that some advocates tend to forget it sometimes. The first thing that tribunals do not like are disorganized or scattergun questioning. It's nice to have an advocate that has a theme. He's dealing with an area of the case. He runs through with a witness all the relevant questions on that area, and then he moves to his next theme, his next area, and he deals with that. It's easy to follow, it's easy to understand, it's easy to be persuaded if it's a good case that the advocate knows what he's doing and that he is knocking down the other side's case in a suitably, sensibly organized way. If the questioning hops about from subject to subject and document to document without any apparent pattern, it's not helpful to a tribunal. Second area that I don't think is very helpful to our tribunal, but again, it's not uncommon, is to cross-examine on credit, trying to make the witness look dishonest or forgetful or deceptive, when in fact the documents are all consistent with what the witness says. To me, it's a waste of everybody's time. A lot of advocates like it because they can sometimes score quite a lot of points and embarrass a witness, but it doesn't really help the tribunal answer the overall questions unless that witness is of such central, crucial importance that it knocks out a huge piece of the case. Otherwise, to me, it's a waste of the time. The third element, and this is a difficult judgment, it's telling the tribunal what they already know. Wasting time on going through stuff that they already know, whether it's law, whether it's fact, whether it's technical areas, clearly is not productive in persuading them to reach a view that you are right and the other side are wrong. So for me, these are all areas that, or techniques that you want to try to consciously rule out in terms of any advocacy efforts that you're making. And I think on that note, I've run out of my time, so I'll summarize it with the one easy question, the one final question: how can I make it easy for the tribunal? If you can answer that question, I think you've gone a long way to solving your advocacy problems. Thank you very much.
Thank you, Anthony. I guess that's the million-dollar question, right?
Yeah.
I wish I had the answer to that. Thank you for your helpful presentation. Now we will be moving on to our Q&A session. I ask all the speakers to turn on their video. It would be helpful to have you all on screen. Great. We have some really interesting questions. And first, I will start with Brenda. Audience asked, choosing an arbitrator seems like a very important task. Post-COVID-19, is it important to consider technical qualifications and such as running a virtual hearing? And also, how do you research arbitrators' procedural preferences or any other preferences for that matter?
I think it's important that the arbitrator have access to an assistant that has technical skills. I don't think it's absolutely imperative that the arbitrator, him or herself, is really technologically competent, but they can't be technologically incompetent. As long as they're okay and they have someone sitting with them who can manage the process. In reality, often the technological pieces are run by the service provider that's doing all of the data manipulation and the document sharing and the video conferencing, so that a lot of that technical bit is dealt with by the service provider. You just need an arbitrator who's comfortable being in front of a camera, knows how to turn on and off mute. I had a couple of occasions where they didn't know that. But as long as you're kind of at basic level that I think most of us have gotten to by this point, you should be fine. In terms of how you research an arbitrator, a lot of it is, I mean, if you're an experienced practitioner who has a lot of background in the area. A lot of it you're bringing with you just from personal experience and the experience of your colleagues. But if you are newer to the area, talk to people, ask questions of, you know, similarly situated lawyers around you. What do they think of this person? Who would you recommend for this type of dispute? Obviously, you're not disclosing confidential information, but give a broad parameter of what the dispute looks like, and then just ask your friends in the community what they think. There are other resources out there too. There are a few providers that are attempting to put together lists of arbitrators and scorecards. The difficulty with some of those is anyone who lost is going to give a bad score. And so, well, almost always. So you have to take those with a bit of caution, but they do exist.
Thank you very much. The next question I have is, I think Dr. Park can address this. Can you file for an interim measures application before arbitral proceedings has been started?
Yeah, certainly. I think that you can consider two possibilities. The first one is that you go to the court to seek an interim relief before you start arbitration. As I mentioned, many jurisdictions provide such a mechanism where the court lay hands for the litigants or arbitration potential applicants to get a certain emergency relief. The second approach is to seek an emergency arbitration. Even though you did not file a request for arbitration, you then still seek an emergency arbitration. And emergency arbitration is resolved within normally 2 weeks or a little longer, 3 weeks. But probably once you file an emergency arbitration, you may need to prepare the request for arbitration. So some institutions require request for arbitration be filed together or right after the emergency arbitration application. But in any event, you have an option to go to the court or to the emergency arbitration, even before the filing of the arbitration.
You're very right. Just to give you our rules as an example, you're able to file for an emergency arbitrator application before or during and any time before the award is granted. But if you do file for an emergency arbitrator proceedings before the notice of arbitration is filed, then after you file for the emergency arbitrator, you have 7 days to file the notice of arbitration. So Dr. Park, you're right on point. Thank you for that. Anthony, question for you. Which skill set do you give more weight to as an arbitrator, written submissions or oral advocacy in a hearing? The second question also is, there has been increasing hot tubbing of experts and also use of tribunal appointed experts. Do you find those more helpful than the party appointed experts?
Skill sets first then. I think the answer is probably written advocacy overall. And the reason I would say that is this. It's inevitably the case that at the end of the hearing, assuming there's been an oral hearing, the tribunal will go away and write up its decision. You may well be persuaded by what you hear in the hearing as to an oral submission as to who is right and who is wrong, but you are going to have to sit down and work your way through it and write it up. You don't just simply get to the end of the day and say, you win, you lose. Thank you very much. And therefore, a considered comprehensive written document, I think, is very important. But having said that, oral persuasion can be very powerful. Somebody that can take you through the documents at a run at the end of the evidence, you can walk out of the room feeling absolutely convinced that they are right and the other side are wrong. it's very unlikely, or relatively unlikely, you're going to go away and change your mind if you've been taken through in that process. So they are both important, but I think more likely in most cases, a good written submission is going to be the one that will stick. The second question about hot tubbing and party appointed experts, for me, it's very much a matter of, it depends on the case. I think a tribunal that has its own technical expertise, I have a dual qualification. There are many arbitrators who are engineers or have other technical qualifications. They are very well placed to ask questions within their own area of expertise. And listening to an advocate asking questions that it's clear the advocate doesn't understand, and the expert is not able to really improve by giving answers, it isn't very helpful to anybody. But on the other hand, a tribunal that doesn't have that expertise may actually miss the point completely. I think there is a big benefit in having the two experts there together. I think when they're both sitting side by side, they both get the same question at the same time, you get much better answers from them. So I'm a big fan of hot tubbing, but only with the right tribunal and only on the right sort of areas. Party experts, it's quite traditional, it's well known, certainly better than nothing, but I do like to hot tub in the right case.
Thank you. Good to know. And also the last question I have is, when it comes to efficiency, how does the HKIAC rules benefit the parties? I guess that's something I can answer. There are many cost and time-saving measures that HKIAC provides to its parties, which makes it different from the other rules. Some of the unique features to HKIAC is that you can choose how you pay your tribunal. So ad valorem scale is used at ICC and CIAC, and UNCITRAL and LCI use hourly rate. We at HKIAC provide the option of one or the other. The default rule, however, is the hourly rate, but we do not designate one way or the other. So we provide the party autonomy on choosing which way to pay. Also, the different distinguishing feature that we have is also the emergency arbitrator proceedings. We have designated it specifically into our rules. And we also have the tribunal test secretary services within our legal staff, which are well qualified within our secretariat, as well as others who have received the training from HKIAC. Just for time, I won't run through all the time-saving measures, but some of the features we have is early determination proceedings and also expedited procedures, which are also specified in our amended rule, 2018 rules. So if you would like more information on that, you can visit our website or also contact me, and I'd be happy to provide more information on that. The last question we have is, what are the recommendations and advices which you can provide to attorneys who are working in domestic arbitration and willing to work in international arbitration? I open that to the floor. Anyone want to step up? Thank you, Brenda.
I'll go first. I'm sure we all have things to say on that topic. I think the reality is that as laws harmonize within countries, as more countries adopt the model law or elements of the model law for both their domestic and their international practices, the distinction, the traditional extreme distinction between domestic and international is fading. And a lot of the international best practices that we've been talking about are equally applicable, even if you're in a domestic setting. So the advocacy that Anthony was talking about, that still applies. The selection of arbitrators, that still applies. You may have limitations, but it still applies. A lot of the pre-dispute or pre-filing elements that Dr. Park was talking about, all those still apply. So start running your domestic disputes as if you were running them in an international context. You'll get the experience, and then it'll just be second nature to move into that environment, would be my advice.
If I may add, I agree with what Brenda has said. I guess that all skill sets and the nature of dispute resolution that are developed in the domestic arbitration would generally apply to international arbitration. There are some differences between domestic arbitration and international arbitration in terms of the rules. I think that the rules of international arbitration are substantially developed, and it's being reflected in the Arbitration Act in many countries as a part of the Untitled laws. And also, and as Brenda has mentioned, there are more and more convergence. So anyone who would like to develop their career from domestic arbitration to international arbitration, probably they would accustom to the soft laws that are developed in international arbitration, such as IBA rules or Charter Institute rules. Then I think that they would know how to navigate in the international arbitration community. Thanks.
Thank you, Dr. Park.
Maybe if I can just chip in a couple of words.
Yes, please.
I'm not sure what the background of the questioner is, and I'll be brave enough to slightly disagree with Brenda. I think there are some jurisdictions where, I mean, she's right in many places, but there are some jurisdictions where I think domestic and international are still very different. And it may be that the questioner comes from a jurisdiction where that's the case. And I think if that is the position for the questioner, my advice would be to get as much exposure as possible to international arbitration. And if I can, I'd put in a plug for the Chartered Institute of Arbitrators, because they run courses on specifically on international arbitration, where I think their aim, what they try to do, is to introduce these more transnational concepts, which, as Brenda quite rightly says, are now coming into very many domestic jurisdictions. So if the questioner doesn't have that experience domestically, that is one place to look that I would recommend.
Thank you, Anthony. We have a few minutes, so one last question. What's the attitude in the international field to guerrilla approach? Any takers?
We all hate it unless we all hate it unless it's on behalf of our client.
The honest answer.
Well, I'll give you the arbitrator's answer. We all hate it.
Okay.
Stop.
Well,
Okay.
Completely unproductive.
Yes.
No, I agree with that. From a personal perspective, I completely agree.
I think that there need to be a certain room for the parties and the council to exercise as much as possible to, present a case, but there would be a limit. And I think that ultimately the rule to ensure that the integrity of arbitration is maintained should be governing as to these guerrilla tactics.
That's a good note to end. So we will wrap up with no guerrilla approaches are acceptable. Thank you all. Thank you all for tuning in today. I hope you found the presentation as helpful as I did. I enjoyed it very much. A big thank you to all our speakers, Dr. Park, Brenda, and Anthony, for sharing today. It was truly a pleasure having you all here. We'll be putting up the recording of today's webinar on our website. If you missed any part of it, please check it out on our website. We do not put up the PPTs. If you would like a copy of that, please reach out to me or our BD team separately. We will also be providing our speakers' contact information please on our website, so please contact them for any questions or inquiries you may have. Thank you, everyone. Hope you have a very fabulous rest of the week, and thank you for tuning in today. Thank you all.
Thank you very much. Thank you.
Thanks, everyone.
Thank
Thank you,
you. Bye.
Bye-bye.